Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is NORHASLIZA binti Chan Boylong Elais Ali 059291, and today I'm going to talk about the summary of historical background of family law in Malaysia. The historical background for family law in Malaysia. The laws govern on the family matters of Muslims and non-Muslims in Malaysia are Law Reform, which is Marriages and Divorce Act 1976, which is known as LRA 1976 for non-Muslims, and also the Islamic law of the states and federal territories of Malaysia for Muslims. First, we are going to talk about the marriages and the dissolutions of marriages in Sabah. As you all know that Sabah is dominated by the Christian, which is more than the Muslims populations. So first we are going to talk about the Christian marriage, where there are no specific laws and legislation regulating betrothal, and also the common law of England applied in cases of breach of contract of marriage, and we can refer it to the Christian Marriage Ordinance and also the Marriage Ordinance 1959. And there are also the elements of valid marriage, which is first, in the terms of the age, the minimum age for male is 16, where the female is 14 years old. The consent of parents or guardian also very important, which we can get from the father, mother, and even high court. And the third one is kindred and affinity. It is just as the same as in England via applications of law ordinance. And also the polygamous marriage is not valid, as we can refer to the section 494 according to the penal code. And then the consent of parties, it is free consent. If we talk about the customary marriage in Sabah, we can refer it to the Marriage Ordinance 1959. And the dissolutions of marriage in Sabah can be caused because of monogamous marriage, as we can refer to the Divorce Ordinance 1963, the native customary divorce, where the dusans and murids can divorce each other without any reasons, and the Chinese customary divorce based on mutual consents. Next, we are going to talk about the marriage in Sarawak. It is based on the Church and Civil Marriages and the Church and Civil Marriages Ordinance 1958. In the terms of age, both parties should reach 14 years old, and the consent of parents or guardian. For the minors, European age below 21 and other person age of 18, the High Court and also the marriage registrar can give the consent. Kindred and affinity. It is a void marriage within the degree of kindred. And lastly, sound mind. For the Chinese marriage, we can refer to the Chinese Marriage Ordinance 1933. The marriage must be registered within 1 month with the registrar, and the female must obtain 15 years old, as we can refer to the case of Law Chai Ying versus Lau Ying Lai. And the divorce cases, we can refer to the case of Chan Binyo versus E Seok Chu, where the Chinese customary law applied. The native marriage, which is not include the Muslims populations. First, we're going to see the Si Dayak, where the Tuan Rumah heard the cases of breach of promises of marriage, while the Orang Ulu, the Tuan Kampung heard contract of marriage. The divorce can be caused by the mutual consents, by the payment of fine, desertion, concept of temporary divorce, and the dissolutions of marriage can be referred through the Matrimonial Causes Ordinance 1958. And now we are going to talk about the marriage in Peninsula. First, the Civil Marriage Ordinance 1952, or known as CMO 1952. The requirements of valid marriage in the terms of age, the male should be 16 years old and above, while the female 14 years old and above. And the failure to comply this requirement lead to the marriage void. And then second, the consents of parents or guardian. For the minor, they can apply to the state authority if their parents or guardian refuse to give their consent. And the third one is kindred and affinity. It must not come within the prohibited degree of kindred and affinity. The failure to comply with this requirement also lead to marriage void. And also the avoidance of marriage by prior existing marriage. Either party cannot have marriage already on such date of marriage. And then lastly, the consents of parties. It is a mutual consent before the registrar of the marriage, and also the failure to comply with this requirement lead to the marriage void. And then the Christian Marriage Ordinance 1956, which is known as CMO 1956, the requirements of valid marriage of this ordinance are just similar with the CMO 1952 in the terms of age, consent of parents and guardians, kindred and affinity, avoidance of marriage by prior existing marriage, and also the consent of parties. However, the marriage and the stated age should be solemnized through license granted and the authority of the registered Christian church, religious denominations, Christian religious bodies. And the customary marriage in Peninsular Malaysia, there are only two customs, which is the Chinese customs and also the Hindu customs. And we can refer to the case of Dorothy T. Yen Nam versus Li Fah Kui. The Divorce Ordinance 1952, which is known as the or 1952. First is the nullity of marriage. The prohibited degrees of affinity, absence of consent, and soundness of mind, either party was suffering venereal disease, pregnancy by some person, willful refusal to consummate the marriage. And secondly, the dissolutions of marriage. It can be caused by the adultery, desertion at least 3 years, cruelty and unsoundness of mind. And third, judicial separation. It is legally allow parties to live apart from each other. And for the Chinese customary, for the divorce, it can be because of the mutual consents or unilateral actions of the party. And we can refer to these two cases, which is the case of Un Ni Yu versus Ng Yun Tai, and also the case of Mary Ng versus Oi Gim Tiong. And lastly, we are going to talk about the differences between the customary marriage and the statutory marriage. First, the customary marriage, which is a marriage contracted according to traditional custom and recognized by customary law, usually includes two customs, which are Chinese customs and also the Hindu customs. While if we talk about the statutory marriage, this type of marriage is referred to marriages performed according to a specific law established before the introductions of Law Reform Act 1976, which are first the Civil Marriage Ordinance 1952, the Christian Marriage Ordinance 1956, Chinese customary marriages, Hindu customary marriages, and also the Divorce Ordinance 1952.